to contact with the youth criminal justice system, um, and what we could do to help them achieve better outcomes. And what we learned about just how the process itself can sometimes alienate young people and their families. And what we try to do to improve the youth criminal justice system in Ontario as a result of that, and how it interacts with and always has to be considered as running side by side with the family law system for those children who also have ongoing family litigation. So when I'm done all that, I'm happy to take as many questions as we have time for. So please put them in the chat or whatever else you can do. And don't be afraid to ask anything, especially if you're totally new to this. It's really fascinating, at least I think so. And I'm happy to hear any questions at all. So I'm sharing my screen now. I'm just going to assume, unless I hear from Maria or anyone else, that this is working well. And the PowerPoint will be made available to everyone at the end of the session today, of course, if you would like it. And here, there we go. Okay, so why do we have a separate youth criminal justice system in the first place? Now, why was Parliament intent on setting up a different system to treat children from adults? What are these differences? I hope to go over all of this as much as I can in the time we've got and I'll highlight the most important ones. And just to emphasize again, that it's a really rewarding system if you have the chance to operate in it. You know, adult courts can have its good days, but also its challenging days. In youth court, I find the success stories far outnumber the stories where you're frustrated. And there are just many great opportunities to really meaningfully connect youth with what they need to foster their rehabilitation and to make sure that they're not going to come back and reoffend, especially as young adults. And there are a variety of really fantastic resources that exist. If this is an area you're getting into or you're interested in, I'm also happy to connect you to those resources online, in print, and just people to speak to help you if it's something that you want to learn more about. So the Youth Criminal Justice Act came into force on April 1st, 2003. It replaced the Young Offenders Act. I know that language kind of lingers. It's just got its way, I guess, with the press in particular. But the term young offender is actually outdated now. It's young person under the Youth Criminal Justice Act. Under the Young Offenders Act, Canada had the dubious distinction of having the highest per capita rate of incarceration for young persons anywhere in the developed world. And I think this is really hard for Canadians to understand because it doesn't seem like what we would have been like. But if you broke down the rates of incarceration back in the 1990s in particular, between Canada on a province-by-province basis and the United States on a state-by-state basis, the leaders, so to speak, in incarceration weren't jurisdictions that might come to mind. It wasn't Texas or Louisiana or Florida or whatnot. The leaders in incarceration of youth were our Western provinces, whose rates of incarceration for our Indigenous young persons in particular were simply astronomically high. About 20% higher on average than the typical comparable US state. And the vast majority of youth who were being incarcerated for non-violent offenses. So there seemed to be a universal agreement at this time that the system was too expensive and was quite frankly unfair to many youth, and there had to be a better way. So the Youth Criminal Justice Act was designed intentionally, to reduce the rate of incarceration and indeed just formal prosecutions in general for young persons. And the first case to really tackle this at the Supreme Court of Canada was called CD and CDK. And I just included a paragraph there for you in this presentation, which I think is just the most pithy statement we've had on this, is that the YCJ was intended to reduce the unacceptably high level of youth incarceration that has occurred under the Young Offenders Act. The preamble to the new legislation states clearly that the youth justice system should reserve its most serious interventions for the most serious crimes, and thereby reduce its over-reliance on incarceration. And while I haven't chosen to, inundate you with statistics in this presentation, suffice it to say that our rates of incarceration for youth are dramatically lower than they were before the introduction of the Youth Criminal Justice Act. And there's no reason to believe that that has made us any less safe. In fact, generally speaking, I think it's regarded as been a success story and that the Youth Criminal Justice Act is working quite well overall. Okay. If you haven't been in youth court before, here are just some of the principles and ideas I'd like to bring to your attention. You've got to walk in there with the right mindset and the right attitude. It's a fundamentally different place from adult court. As we're going to see, the philosophy behind the legislation is different. You've got to come in there with that kind of perspective in mind. I really like this line from an American case by Justice Sotomayor, where she states clearly that children cannot be viewed simply as miniature adults. I don't think I could phrase it any differently. I think the mistake some criminal lawyers make who come into youth court, who are used to being an adult criminal court, is they take the view that, yes, everyone's younger and everyone's a bit shorter, but really it's the same place. It's not. There's a completely different approach that you have to wrap your head around. And if you embrace it, you can have great outcomes. Parents and families and other relatives should always be involved. And as we're going to talk about half of the young people who appear in youth criminal court have prior or ongoing involvement with the child welfare system. That's what we call crossover youth or dual system youth. And understanding all of this is really, really essential to doing your job properly when you're in criminal court, whatever capacity that is. I am not obviously a doctor myself or a scientist, but I can also tell you that it is just generally accepted now that the human brain continues to develop in really important ways well until one's mid-20s. Okay, and it's the parts of the brain that are developing that deal with risk assessment and judgment and impulse control and all the sorts of things you kind of associate sometimes with bad decision making and why people end up in criminal court. That I think is also an essential thing to keep in mind. It's not just that young people are literally younger than adults and have less life experience. They're still developing in really, really important ways. And that all has to be factored into how we assess their moral culpability for what they've done. Section 3 of the statute contains a statement of principles. I've just sort of highlighted a few here that I think are important to bring to everyone's attention. The purpose of this statute is to hold young people accountable through measures that are proportionate, yes, to the seriousness of the offense, but also the degree of responsibility of the young person, recognizing again that we're dealing with youth, not adults. And the criminal justice system for young persons must be separate from that of adults and must be based on the principle of diminished moral culpability. That principle was established as a constitutional right in the 2008 decision of DB from the Supreme Court of Canada, which dealt with some of these presumptive adult sentencing provisions that existed in the YCJ when it was first enacted, and they're now gone. It's then been incorporated into the statute in 2012. And this is something also vitally important to remember. A young person, regardless of the crime they have allegedly committed, they enter into court with this presumption of diminished moral culpability. And it is only in extremely rare cases that the Crown would ever seek to rebut that presumption. Turning now just to some of the differences in substantive law and procedure that govern youth versus adults. Again, just to give everyone an idea of what's different, okay, when you come into youth court. Let's say we're dealing with a bail hearing, okay? One of Parliament's explicit goals to reduce the rates of incarceration for youth was, again, to reduce those negative consequences for young persons. And that's at all stages of the youth criminal justice process. There's a tendency to focus on sentencing. And of course, we're going to get to sentencing, but it's not exclusive to sentencing. And the Youth Criminal Justice Act achieves this in the bail regime with its own set of provisions, which are different than some of the adult provisions and different in very, very important ways. And while the Act does sort of bring in the adult provisions if necessary, you'll see that in Section 28, it says you only rely on the adult provisions when there's nothing in the Youth Act that would directly address the matter in question, and as long as those adult provisions aren't inconsistent with the principles of the Youth Criminal Justice Act. So I can tell you, as a judge who hears youth bail hearings from time to time, it is unusual that it is necessary to draw from the Adult Criminal Code. Really, the YCJ's bail regime is sufficiently self-contained that you can get all of the principles and all of the decision-making tools you need right there. And some of the tests that are applied are different in very important ways. So again, if you're a lawyer in particular, but even if you're any other kind of justice system participant listening to this, don't come into youth bail court and think it's the same as adult bail court. You're going to make a terrible mistake, and you're probably not going to rely on the right sections of the right statute, which will lead to difficulty. Most importantly, okay, detention measures in youth court can never be used as a substitute for child protection, mental health, or other social measures. It's a bit of a trite observation, and one I may repeat today quite often, that the vast majority of young persons who interact with the justice system do have troubled backgrounds. And the Crown will often provide information at the bail hearing that they've obtained through obviously other sources about the young person's family situation, educational background, and generally speaking, community connections. Some of this will include Johnny doesn't seem to always listen to his parents. Johnny doesn't go to class all the time. Johnny isn't known to obey his curfew properly, etc. But we have to remember what criminal court is. It's focused on the criminal charges and the need for intervention to address that. It is not then somehow an open door to use the criminal justice system to address other areas of concern in a young person's life that all children and youth go through that are better suited to just parents or caregivers or other institutions in society, perhaps such as the school system or whatnot. And sometimes these concerns can bleed together a little bit and people can lose sight of this. But it's right there in Section 29 as a starting point. The other part of Section 29 that I should have included, and I can't recall if I've got a subsequent slide on this, is just that the onus in youth bail hearings is always on the Crown. So you'll hear in adult court a lot, well, the accused is charged with a certain offense, and because of the particulars of that offense or his background, is in a reverse onus situation. He has to justify his release from custody. That never happens in youth court. Everything is a Crown onus. And if the Crown seeks to detain a young person, they always bear the onus of demonstrating why that must occur. The grounds that we know about for bail hearings are roughly the same. You've got primary grounds that a young person may not appear in court. That's very rare. It's difficult to imagine a young person absconding. And then secondary grounds about whether or not there's concern that the young person might commit a subsequent offense. But in youth court, this is limited to what's called a serious offense, and that's defined in the Act. So not all crimes will qualify. And even if there's a concern that the young person might commit minor crimes if they were to be released, say thefts or something of that nature, those are not, quote, serious offenses for the purposes of the Act. And the reason that this was set up, of course, is that we don't want to see young people detained and held in custody with all the very serious negative ramifications that come with that for offenses that, while of course they shouldn't be occurring, are better addressed through non-custodial means. So you would only resort to a detention order for a secondary ground reason in these cases involving serious offenses, typically crimes of extreme violence, perhaps involving firearms. The tertiary grounds, if you're familiar with this, also exists in youth court, i.e. where, public respect for the administration of justice may require a detention order in some very limited cases. But that is also restricted in youth court. It's already a tough test to meet even in adult court, but Parliament included that there must be exceptional circumstances that would justify the use of this tertiary ground basis, looking at a variety of factors that I've included there for you. Again, unless a young person was charged with something extremely serious, for example, a murder allegation, it is very difficult to imagine how the tertiary grounds would apply in youth court. The parallel to this, of course, is, well, what happens at sentencing? Okay, so you've gone through youth, the bail regime, excuse me. There's been a case management process. What about we get to the end of the road? What is it worth, so to speak? What do we expect out of youth court for these dispositions that might be different than what we would expect in adult court? Well, again, unsurprisingly, the Youth Criminal Justice Act was designed to reduce the use of custody for youth. So the sentencing provisions of the Youth Criminal Justice Act are structured very differently for that reason. There's an emphasis on community-based dispositions, and there are unique sentencing options that really just have no comparison in the criminal code at all. And I can tell you, as a judge sitting in youth court, you really know good youth lawyers from those who are just dabbling, because the good ones will know about these differences and be able to highlight and bring them to your attention in appropriate cases. In other situations, unfortunately, I find some lawyers fall into the trap of using adult sentencing language, which kind of betrays their inexperience in the youth criminal justice system. Another interesting aspect of youth court is that if I were to impose a custody and supervision order, which is, again, not common, but does happen, I can set the level of custody. Now, we have different levels of custody in youth court. One's called secure custody, one's called open, and then there's also deferred. This is very much unlike adult court, where pretty much it is jail, as in a provincial jail or a federal penitentiary. But we have very interesting options in youth court. And of course, young people can also have a sentence review. If I sentence someone today, to custody or otherwise, I can bring them back after so much time and review the sentence and possibly alter it, especially if I've seen good evidence of rehabilitation. That's not something we can do in adult court. After I've passed sentence, I am finished. And it's only the Court of Appeal that could potentially change the sentence if I've made an error. Okay, so what are some of the principles I just want to bring to your attention for sentencing? Section 38 lists the purposes and principles of sentencing under the YCJ. Again, sentencing is meant to hold a young person accountable for an offense through the imposition of just sanctions that have meaningful consequences for the young person and that promote his or her long-term rehabilitation and reintegration into society. Some sentencing principles that are commonly applied in adult court do not apply in youth court. Most importantly, general deterrence. Many Crown attorneys in adult court rely upon this sentencing principle in particular to justify jail or prison sentences, particularly for very serious crimes. Understandable. But in youth court, it is not in the statute, and the Supreme Court has been quite clear it has no basis in youth court whatsoever. Specific deterrence and denunciation have some role to play potentially. They're optional sentencing principles, but generally we're just talking about how do we promote the young person's rehabilitation and long-term reintegration through something that holds them accountable, a meaningful consequence, but again, always in the backdrop of the overarching goal of the legislation, which is to reduce the rates of incarceration for youth across the board. Okay? And of course, as we're going to see, other principles apply for our most vulnerable young persons, including, for example, the Gladue principles, which obviously apply to adults as well. And all available sanctions other than custody that are reasonable in the circumstances should be considered for all young persons, again, with particular attention to the circumstances of our Indigenous peoples. Okay, what is the gateway to custody? So think about adult criminal law for a moment. Some cases have a mandatory minimum sentence. You must go to jail for so long. There are not that many anymore, but there are some. In youth court, it's the opposite. There's a barrier that's put up. You cannot impose a custodial sentence as a youth justice court unless the Crown can satisfy me that one of these four gateways has been opened. The starting point is no custody. The most common one used is whether or not the young person has committed a violent offense, and we'll go through that in just a moment. B and C deal with a young person who's had prior dispositions and just doesn't seem to be complying with them. So if you happen to accumulate a youth record and keep coming back before you've turned 18, obviously at which point you would be in the adult system. And then in exceptional cases, there are some rare sets of offenses where even if it may not qualify as a quote violent offense, the imposition of a non-custodial sentence might be inconsistent with the purposes and principles of sentencing in the Act. Again, those are very unusual, but they do sometimes exist. What is a violent offense? So offenses where an element of the offense is the causing of bodily harm. So you can imagine crimes of particular violence, an attempt or a threat to commit such an offense, and then finally, an offense in the commission of which a young person endangers the life or safety of another person by creating a substantial likelihood of causing bodily harm. And I should be clear that bodily harm can include psychological harm as well. So prior decisions have concluded that typical crimes of violence often qualify: robbery, sexual assault, certainly assault causing bodily harm and aggravated assault, maybe a simple assault if serious psychological harm resulted. It's not always clear though, and there's some mixed and growing jurisprudence about whether or not we should continue to interpret this section the way maybe it's been classically interpreted. The Alberta Court of Appeal released a decision within the last few months where a dissenting judge in that case called into question whether or not even sexual assault is actually a violent offense for the purposes of the Youth Criminal Justice Act. I don't want to take us too far down that path here today, but I just do want to bring to your attention, and excuse me as my lights on a dimmer have just gone off, that you have to be careful in every case not to assume anything. And you should, especially if your defense counsel, hold the Crown to its high burden of proving that this really is a case where the gateway to custody has been opened. Exceptional cases, as I mentioned earlier, again, are those non-violent cases where anything other than custody might undermine the purposes and principles of the Act. The circumstances of the offense have to be shocking to the community. The leading case remains REW from 2006, where a young person was an accessory after the fact to a murder, not directly involved in the murder itself, but after the murder occurred, helped the adult offender dispose of the body and do some other rather gruesome things. So that's the kind of level of offense we're typically talking about. Although there have been some other cases that have applied this, say, for example, a serious arson where nobody was hurt, but obviously somebody could have been. child abduction cases where, again, the child was physically hurt at least, and very serious drug trafficking cases, for example, for trafficking in fentanyl or something of that nature. But again, the message I'm trying to get across to you all here is that it is a small subset of cases where a custody and supervision order is even lawfully available. The Act is always directing us towards non-custodial dispositions. What is open custody versus secure custody actually like in reality? I had an opportunity recently to actually tour a secure custody facility and an open custody facility. Secure custody in the GTA for boys is the Roy McMurtry Center. It is still, how shall I say, a more inviting place to be than an adult jail. I can assure you of that. But nevertheless, still a closed security facility where there are very significant restrictions on your liberty. And, it does feel like an institution. Open custody facilities are different. This is a picture of one in Brampton. You could walk by an open custody facility in your neighborhood tomorrow and have no idea that it was there. They're not meant to attract attention. They're not advertised in that regard. And the restrictions on liberty for young persons in these open custody facilities are much less than in a secure facility and 1,000 times better than what one would experience in an adult facility. Young persons can earn reintegration leave, and they're allowed to go into the community sometimes if supervised. For example, they can go to special schools. So they're not going to school in the institution. They can go somewhere that feels a little bit more like an actual school. They can earn privileges to go, to a local park or whatever. They can get time with their families. It's much more based, even though it's custody still technically, on reintegrating the youth as they demonstrate compliance and as they rehabilitate themselves back into society to a degree that is just not present in the adult correctional system. And for what it is worth, if anyone is ever interested, I find actually going to these places on arranged tours when you won't disrupt the lives of the young people there are really rewarding, because you get a chance to see what's actually happening to children and youth when they're taken into these facilities. And I will give a great deal of credit and applause to the Ministry of Children in this province, which I think does an exceptional job at trying to make these places as welcoming as possible, recognizing that there's still youth serving custodial sentences there. Secure custody, again, on the right, if you're looking at the screen that I'm looking at, you'll see an overhead shot of the Roy McMurtry Center. It is what it is, but I can assure you, having been to adult jails as well, it is still a much more welcoming environment overall, and there are opportunities there for young people to earn privileges and liberties that they simply don't have in the adult correctional system. For girls in the province, it's Sundance in the Kingston area. There really aren't, I don't believe, many secure facilities left for girls. There just aren't many that end up getting sentenced to secure custody. And one factor I have to consider when sentencing a young person, if I were to sentence them to a custodial sentence, is where are they going to be placed? Because if I find out they're going to be placed potentially hundreds of kilometers away from their family, and their family may not have the ability to travel there, if at all, to visit them, that's serious. Because, of course, removing that young person from the supports they have in the community could be quite detrimental to their long-term rehabilitation, but it may be necessary in some cases. Case conferences are also an option in the Youth Criminal Justice Act, expressly authorized by Section 19 of the statute. You can bring people together, parents, family members, other community members in a young person's life, to literally sit around a table. We have a table here at 10 Armory Street that we use for this sometimes in Toronto. Let's talk about this case. Let's talk about what's happened. Let's hear from the people who care about this young person and know them, to find out what's gone wrong and how we might be able to come up with a better outcome here. And I find just going through this process and having everybody contribute and learning and allowing the young person in particular to know that their voice is heard, and I want to know their perspective on everything as well, can be extremely rewarding and often lead to excellent outcomes. These aren't incorporated maybe as much as they could be. I'm a very big fan of them. I highly encourage everyone to consider them. They take a bit of organizing, but when people come together and everyone has a chance to literally just talk to one another about what's happened, often excellent results can happen. And from my point of view, I'm under the impression, at least, that the young people feel that it's a rewarding process too, because they're not just being lectured at by me in a courtroom. Now they're hearing everyone talk and hear the young person too, and their voices heard. And we'll try to come up with something while addressing the offending behavior that put us there in the first place. Youth Court also has the option of me ordering what's called a Section 34 assessment. Section 34 assessments are prepared by mental health professionals. In Toronto, it's CAMH. They can be ordered based on any concerns about a young person, really. There's quite a broad discretion afforded to me to order them. Classic mental health issues may be a basis, but also just behavioral issues, educational concerns, and other matters. They're completed by the mental health professionals down at CAMH. We get a very comprehensive report back. They interview the family, look at education records and other sources of information, find out what's going on in this young person's life and what resources may be available to them in the community in particular to help address that risk of reoffending so that they don't come back. They're really just exemplary. They have a lot of very private information in them. They shouldn't be ordered too easily. And of course, I would want to know from defense counsel how the young person felt about it and what their perspective was. The report comes back to me as the judge and the Crown Attorney's office, although there are restrictions on what use can be made of it. But again, I find in a serious case where things have become complicated, and certainly where the Crown is seeking custody, almost inevitably, I would want to ask about, is this a case for a Section 34 assessment? So we can come up with the best outcome possible to ensure the young person's long-term rehabilitation is prioritized. And then when the report's finished, if they have supports in the community that are helping them, I can release the report or portions of the report to those service providers to help them treat the young person better as well. There's really just no equivalent to this in the Adult Criminal Code. You can order reports in some circumstances, but not just generally like we can in the Youth Criminal Justice Act. Finally, there are some very interesting specific youth sentencing options. The Intensive Support and Supervision Program, again, focused on youth with mental health or other special needs, meant to keep them out of custody. It's one of those cases where the judge is kind of on the fence about whether custody is necessary. They will work with the youth and their family in a very intensive basis. They're really extraordinary. The people that run these programs care deeply, and I'm always impressed when I get these reports back. And then another one for youth in custody is called the Intensive Rehabilitative Custody and Supervision Order. Effectively, it means, yes, the young person has to step into custody, but we can secure funding of up to $100,000 per year to assist the young person with the programming they may need, even as they turn 18 perhaps, and remain in the justice system to serve the sentence. If they committed their crime when they were 16 or 17, they're going to be in for a bit. It is just phenomenal, the amount of resources that we can produce. And often the IRCS sentencing option is considered if the Crown is saying, this is so serious, we might even seek an adult sentence in this case. Well, then the defense can come back and say, let's explore the IRCS option. Maybe this is the better way to blend the concerns that exist in this case without jumping all the way into an adult sentence. Again, there's some procedural requirements, won't always be appropriate, but truly a well-funded and just incredible program that can assist young people in custody even, and as they plan to be released back into the community, to give them those resources that they need. Adult sentencing applications. I'm not going to spend much time on this because I want to make sure I get to the Crossover Youth Project. There's a case before the Supreme Court of Canada now on reserve, the first case they've ever taken on whether or not, or how the adult sentencing provisions in the Youth Criminal Justice Act should be interpreted. So I'm reluctant to say too much because we're all waiting for that case to be released. But I will say this. The test in the Act requires the Crown to prove that the presumption of diminished moral culpability has been rebutted, okay, and that a youth sentence would not be of sufficient length to hold the young person accountable for his offending behavior. And that's the Court of Appeal version of part of the case that's gone all the way up to the Supreme Court now. It is difficult for the Crown to rebut that presumption, but not impossible. There are some cases that demonstrate particular cruelty, perhaps, or violence, or planning and deliberation by a young person when they're a bit older, in particular 16 or 17, where you might say this is sufficient to cross the threshold, but very rarely done. I mean, I would estimate less than 1% of all cases, and perhaps a lot less than 1% of all cases, of the Crown bring an adult sentencing application, generally reserved for murder cases, but sometimes in other ones as well. Okay, youth records, just to gloss over this, very complicated subject with the time I have. There are serious restrictions on youth records. There's a publication ban on every youth who's charged or investigated by the police. That publication ban is never changed unless an adult sentence is imposed that lasts forever, even after they turn 18 or even if the charges are withdrawn. And the youth records associated with the case can only be accessed by a select number of people for a certain period of time, and access outside of the restrictions of the Youth Criminal Justice Act is illegal. It's in fact an offense. So highly do we value the privacy rights of our young people. In the slides, I've gone through some of the provisions. What I will just say is this: if you ever come into access of a youth record, presumably in the course of your job or your act as counsel or whatnot, just be careful. Make sure you are satisfied you have lawful access to it and it wasn't somehow released to you unlawful. Then it's your professional responsibility to ensure that it's returned or otherwise dealt with appropriately. I included here a chart that I created many years ago when I was a lawyer. This is the best I could do. I'm sorry to simplify this, but the bottom line is the retention period varies greatly depending on what happened to the charge, whether or not the charge was withdrawn, whether the young person was found guilty. If found guilty, what was the sentence? There is no magic about turning 18. Okay? What matters is when the charge was laid, what happened, and what is the time period associated with retaining the youth records. Once that time period has expired, except under a very small number of exceptions, like where the person continues to offend or maybe offends as an adult after they've turned 18, the records are sealed and they're not to be accessed by anyone for any purpose without a youth justice court order. A young person themselves can always access their own records if they wish. But beyond that, they're not to be released. And the whole point is to give the young person an opportunity to start fresh and not have the stigma of the old criminal charges hanging over them for an undue period of time. Okay, let's turn with the time I have left to the Crossover Youth Project. This was a very rewarding project that I was involved in a few years ago. We were trying to look at the outcomes in the family justice system and the criminal system for youth who exist in both worlds. And again, it's about half of the youth in the criminal system who have some prior experience or ongoing experience with the family law system. Why are youth in the family law system in the first place? Okay, typically, it's because they've already been the victims of abuse or neglect or abandonment. They are some of our most vulnerable children and youth who have already, quite frankly, had a very difficult time in their young lives. And then they act out in some capacity and they cross into the youth criminal justice system. How these two worlds speak to each other and how we ensure that what happens in criminal court works harmoniously with family court or the child welfare courts and not in a way that undermines them is just vital to ensuring the best outcomes for our young people. I've described here a bit of the project parameters. It was a partnership between then Ryerson University and the Ontario Court of Justice. We got funding from both levels of court. We had the involvement of a variety of organizations that were involved with children and youth. I was there on behalf of the Ministry of the Attorney General at the time. It lasted about 4 years, and we had pilot sites where we were trying things differently and trying to understand better what worked well and what didn't work well and how we could improve matters, generally speaking. 311 Jarvis Street in Toronto at the time had both youth criminal and family court judges. So the judges there could hear child welfare cases and they could hear youth criminal cases. You can have one judge dealing with both. That model no longer exists in Toronto. 311 Jarvis is only for family law now, and youth criminal all comes to 10 Armory Street where I sit. So what I've called here the two-hatter judge model, unfortunately, no longer exists, at least in this city. It does exist, though, in some other areas, and you can look at the other locations that we chose there, especially areas that were known to have unique challenges in this regard. Belleville, having the largest number of group homes of any city center in the province based on population, and Thunder Bay, of course, in Brantford, because there were so many Indigenous young people who were interacting with both worlds, and what can we do to make their outcomes better? The goal, okay, again, was to learn not only from the service providers, but from the youth themselves. What is happening well and what is happening poorly? And how can we improve how we operate both systems? Some of this might just be procedural changes. Some of them might require resources, but certainly all of it would make us better at what we do. The project was really focused on improving outcomes for youth in care, right? By trying to come up with system-wide responses that would work across all of the different components. I got to tell you, in many of the meetings, the most rewarding part for me was just listening. We had many people who had been through both worlds, who had now turned 18. They were young adults. They were willing to come back and share their stories with us. They don't teach you this in law school, okay? You have to hear it from the people themselves about what they've been through and what they continue to go through and what they feel treated them well or treated them very poorly while they were experiencing this at the time as a child. And a lot of it was very emotional, quite frankly, very moving, but it was highly educational at all times. I've described the model a bit here. I think one of the big takeaways for me was that there's always this tendency for all of us to work within our own silo and not always keep in mind that the young person is existing in other worlds as well. And if we create contradictory plans or orders, we're just undermining the youth. How could they possibly be expected to succeed? That's something I take very seriously now in my current role, when I always want to know what's going on in a young person's life. Who else is setting expectations or rules or court orders for them? How do I make sure that we work together and not apart? Looking at crossover youth in particular, okay, I cannot imagine how difficult it must be to be a child, to be in the place that these children are in, and then have to come to court at least twice, i.e., before criminal court, before a judge like me, and then before child welfare court, before a different judge, with different lawyers and different outcomes. And the only person often who exists in both of these worlds is the young person. Most criminal defense lawyers do not take on family law work. Very few family lawyers, in my experience, will come into criminal court as well. The Crown attorneys in criminal court have no experience in family court. I can tell you as a Crown, obviously you don't work there at all, but you're not educated on it unless you choose to educate yourself. And how we share information between these two worlds is just vital to ensuring that we get the best outcomes. I took it upon myself to sort of, I guess, self-educate and to work in these facilities and on these projects because I wanted to do better. There are some very dedicated criminal lawyers, both Crown and defense, who also take this on, but it is a small percentage of the bar. And I don't mean that critically. Criminal law has become complicated and challenging almost for any case now, and some in particular. But those who choose to devote themselves to this area will often tell me that they love it. And I know I do, and I hope that we can all do better and more people become engaged and interested in it. Indigenous youth, I want to focus on here for a moment. They accounted for 1/2 of youth admissions to custody a few years ago. I couldn't find more updated statistics, while representing about 8% of the youth population. Just take a moment to ponder that. While we've done very well at bringing down the overall rates of incarceration for youth in this country, the unfairness in the system still remains. 8%, but make up 50% of youth admissions to custody. I mean, really, that's just astonishing, right? And it's worse for Indigenous, I think, female youth as opposed to Indigenous male youth. So we still have a long way to go. As well, the Ontario Human Rights Commission examined the overrepresentation of Indigenous children in the care of a Children's Aid Society. This study is a little older now, but that study in 2018 determined that the proportion of Indigenous children admitted into child care, as in child welfare care, was 2.6 times higher than their proportion in the population at large. Okay? And a 2021 census from Statistics Canada revealed that Indigenous children made up 53.8% of all children in foster care. One of the great criticisms, of course, of the residential school system, obviously, was how it destroyed Indigenous families and took children away from them. There remains criticism now that our child welfare system continues to act in this regard, despite genuine efforts to improve it, both from the provincial legislature to its credit and from those who work every day in that world. But it still happens. You may hear the term 60s scoop as if this is something from the past. There was a terrible experience back then, but it is still ongoing in many respects as well, and something that we have to keep in mind. As well, other youth are disproportionately affected by both of these worlds. One of our project sites in Toronto noted that, again, Black youth were overrepresented, certainly in the criminal justice system, and my understanding is as well in the child welfare system. And there is recognized case law now, even in adult court, that talks about having to incorporate the lived experiences of Black Canadians into how we make court decisions as well, and to understand how that may impact, their moral culpability, but also how to craft the best outcomes in court to help them succeed and not to come back into a system, quite frankly, that has been indifferent at best to some of their unique needs. Most importantly as well, a trauma-based perspective to all of this. Understanding that youth who come into these worlds almost always have histories of profound loss, abandonment, abuse, and just trauma in general. They've lost their trust often, quite frankly, in the systems that were meant to protect them and in the people, the human beings behind those systems who obviously have let them down. Trying to work with them so they could feel they've regained some sense of control, and there's an acknowledgement that they have been failed as much as they have made a mistake as well, was really important to the success of this project. And I can tell you again, I don't want to beat a dead horse here, but listening to these young people and have them tell their stories about what they went through and how they felt no one was ever listening to them was really eye-opening to me. Crossover youth could have contact with what we consider the justice system in a variety of ways. It could just be with the police. Maybe charges are laid, maybe they're not. It could be with a CAS worker. It could be with a child advocate, obviously, or a member of the Office of the Children's Lawyer. If they're charged, to come through duty counsel or a defense lawyer. Then, of course, they'll meet Crown attorneys, a justice of the peace, ultimately a judge potentially. And then if they're sentenced, a probation officer, and then other people trying to assist them. And of course, always, where do they live every night? Well, the group home staff and the other people there. You can just imagine navigating all these systems, all these different people that you know have some important role, but you're not exactly sure what it is all the time, trying to make sense of it all and trying to make relationships work, hoping that at least the adults that you're interacting with care and will do their best, can be exceedingly difficult, right? And it's such a heavy burden to place on children in the first place. I can tell you, as the father of two young children, it's tough as it is, just with mom, me, and them. I can only imagine how hard it is on children and youth who have to navigate these two worlds. Something we should all keep in mind as well when we make decisions in these cases. Finally, parents of youth who crossed over into both systems often had their own sad stories as well. Many of them had their own interactions with the criminal justice system, had been the victims of domestic violence, poverty, or mental health concerns. They knew that they had failed to an extent. Most of them, in fact, the overwhelming majority in my experience, were regretful for their own failures, but nevertheless recognized that they were simply overwhelmed and couldn't manage any longer. And then their poor children would have to come into contact with one or both systems. Again, keeping in mind all of these human realities at all times and trying to bring everybody in together, hopefully connect them with what they need to succeed, will make just tremendously better outcomes for everyone involved. And this is what's in society's long-term best interests. Not necessarily a punishment that I could impose just to look at the crime in a vacuum. Let's see what we can do to focus on the big picture here and how we can hopefully come up with an answer to all of this to the extent that I can, recognizing the limits of my authority as one judge in youth criminal court, to try to do something that will at least work with the young people in their community network so that they have that opportunity to succeed. Finally, I think everyone should just be aware of this topic. It gets more attention in American literature than Canadian, but the child welfare to prison pipeline. If a young person comes before criminal court and the Crown attorney says, well, we're not consenting to a release unless someone acts as a surety, what that means is they want an adult to come forward and, quote, sign the youth out and supervise them in the community. Notwithstanding the bail provisions I took you through earlier that said the Crown bears the onus of justifying detention orders, right? If they just take the position that unless the young person has, quote, a surety, that can put the young person in a very difficult position because not everyone has a solid classic two-parent household to rely upon. If you're a youth in the child welfare system, you do not necessarily have an adult who can come forward to help you. Staff from the group home for the Children's Aid Society will not act as a surety. There is simply no adult there to help these young people through no fault of their own. Again, they've been the victim already of abuse or abandonment or neglect. And then they find themselves up against the wall in criminal court as well because they lack resources that are available to other children in youth. The terms we put on these bail orders too can often set you up for failure. If you know that the young person has difficulty complying and they've got behavioral issues, putting them on a strict bail with a lot of conditions almost guarantees they're going to breach and get rearrested. These are some of the other things we thought about. And then suddenly, just being in the child welfare system and then engaging with the criminal justice system once for whatever substantive offense it might be, for which of course you may or may not be ultimately found guilty, sets up a domino effect where you could find yourself racking up breaches and more time in custody, and then your behavior gets worse, and then suddenly we've created our own terrible outcomes, right? Placement in a group home is also something beyond my control. I can stipulate as a sentencing court whether it's secure or open custody. I have no control beyond that. The Ministry of Children places someone at that point. Obviously, the child welfare system has its own systems in place for how youth are placed and where. One of the stories we would hear over and over again was that life in these group homes was very difficult. And oftentimes youth did not feel that their needs were being respected, that their cultural differences were being respected, and that quite frankly, the staff in some of them weren't always amenable to working with them in the manner that they had hoped. I know we can't always expect miracles, but again, hearing some of this really brought to my mind, just how difficult a life some of these young people have. Okay, so that is the end of the PowerPoint presentation. I'm just going to stop sharing there. We've still got some time left. I guess I'm a little ahead of schedule, but if we have any questions, I'm happy to take them now, or any observations people have. Sorry, you're on mute, Marie. I can't hear you.
Sorry about that. I clicked twice. Thank you. So we do have questions already in the Q&A. I have 2 questions. And again, I invite everyone to put them either in the Q&A or in the chat, whatever's easier for you. If you're ready, Your Honor, I'll ask the first question. So the first is, and that's quite a loaded one. What are the biggest challenges that you are experiencing or you experienced prior to your judicial career?
Obviously, that could be an hour-long presentation by itself, but focusing on what I could do here, I think the biggest challenge is getting the information I need, okay? Because in criminal court, the defense lawyers are doing a good job doing what they have to do, defending the charge or making sentencing submissions in a criminal law-focused environment. But what I often need to know more about is, Johnny, Susie, who loves you in your life? Okay, who's caring for you? What is going on? Are you engaged with the family court system or not? Where are you going to sleep tonight when this is all done? Why do you not want to go to school? What is happening? And it's hard to get them to want to open up to me. I'm a strange person they've never met before, or they just know I have some control over them. But getting that quality of information is just vital. That's just as important, quite frankly, as anything I'll learn about the offense itself in youth criminal court. And then how can we incorporate that into the best community-based resources that exist to help that young person? And the really good defense lawyers in particular will know they can go to this program here, where this community organization will help them, where the family is now getting assistance from whatever. And this is how you can have confidence, that there's something out there that's going to work with them specifically, as opposed to me just saying, well, I'll put you on probation and there's the door and good luck, right? Like, I should be doing more than that, but I need the tools and the information to help me get there. So I try my best to get it. I also don't want to drag you through the system too long. Getting them out of the criminal justice system as quickly as possible is also an important goal, but getting that quality of information, I think, is vital.
There was a question also that was asked on the previous panel, I think might be applicable here. The question was what role, if any, can social workers or youth workers involved with the young person before the court? What kind of role can they play?
That's a great question. And they play a tremendous role in youth court. I want to hear from these people in any case where they're willing to come to court. Obviously, you can write a letter or something. That's helpful too. Just come to the hearing. Show me that you're there. And I may ask, are you comfortable just telling me a bit about how you're working with this young person? And what are you seeing? What do you know? The more I know that there's a strong community-based network out there working with the youth, the more I'm confident that the youth can succeed with an appropriate community-based disposition, right? But just seeing those people there, it makes an impression on me. I can only imagine that it makes an impression on the child who sees that these adults actually care about them so much, they will come to the courthouse and tell the judge that they're there to help and that they're involved in the young person's life. Don't underestimate the importance of that, just being seen and being seen to actually make a difference. So I can only offer my praise up so much, but I'll offer up again. If you're one of said people listening to this, thank you for what you do. I don't know how we would function as a society without you, but more importantly, bring that information to me in any capacity you can. You don't need a lawyer to ask you to do it. If the young person and the family are involved with you, and they say, could you please come to this date? Courtroom's open. Come on in. I'll always want to hear from you.
We have a question as well with respect to the detention and custody in the context of whether this is overused. And the question is, what policy change or program supports do you think is needed to help continue reducing the detention and custody population in Ontario for young persons?
Well, I wouldn't take, much aim at the statute. I think the act is actually very well constructed overall. There are places we would all tinker with it, but that's not really the issue. Really, it's a resource issue. You know, the more resources we have available to us, the more I know there are programs or places for youth to go to help them once they get out of the courthouse is really what helps me make better decisions. You know, again, the vast majority of youth that I deal with simply don't have resources in the community. Uh, they really are from disadvantaged backgrounds. Now, I know I don't have any control over that. That's a decision for the different levels of government to make about what they fund or not. And obviously I understand there are many competing demands on the public purse, to put it mildly. I will just say this though, give us more options, give us more tools, give us more facilities, and give us more people who are funded to help. You'll get better outcomes in the long run. I absolutely guarantee it. Toronto, you know, we've got a fair bit. We could always have more. Other parts of the province, I hear from some of my peers, you know, they feel that, you know, more would really go a long way.
Thank you. You spoke a little earlier about the crossover between criminal courts and family courts. So those two hats being worn by some judges. And the question that comes from a participant is, does the crossover still operate, or will it still operate?
So the project itself isn't continuing in an official capacity, but obviously the concept is never going to go away, that we have youth who exist in both worlds, in the family court, the criminal court, have to speak to each other. In any jurisdiction in Ontario where you have a unified family court, my understanding is that it's the Superior Court of Justice then that hears the child welfare hearings. The Ontario Court of Justice isn't involved in that. That's the whole point of the Unified Family Court, which I imagine has many advantages, but one disadvantage of that system is that Superior Court has no jurisdiction over youth criminal court, except in an extremely small number of cases. So it's impossible to really integrate properly because you've got the Ontario Court of Justice, i.e. me and my peers, hearing the criminal cases, and then the Superior Court hearing the child welfare cases, and sharing information between the two courts is so important, but not easy because of the privacy provisions that are in place in both worlds, understandably, to protect the young person's privacy interests. The only person who usually crosses into both is the young person, or maybe the CAS worker, of course, if they're attending both and are able to communicate properly the information. That's just going to be an ongoing struggle. It's just a curiosity of our constitutional system and how our courts are structured and organized. There's really no easy fix to it. In areas where you don't have a unified family court, it may be there are these two header judges left, but those jurisdictions are dropping. And, you know, I don't have an easy answer for that. I try to work with the Superior Court judges in Toronto as best I can and identify these cases, and we try to communicate, but, you know, we're all human. There's only so much we can do. You know, I wish I had something more optimistic to add there, but it's just, you know, Canada's got its own unique features, and this is one of them.
There is also a comment asking if you would be able and willing to distribute your PowerPoint presentation. I think it was of great interest, and there's a lot of material that was covered.
Oh, that's absolutely fine. Anybody can have access to the PowerPoint if they would like. It's, as far as I'm concerned, available to anyone who's curious and interested.
Thank you. I'm just going to look to see if there's other questions that are coming through. So I might have a question,
Sure.
if nothing else is coming in. Youth conferences. Can you speak a little bit under the YCJA? And I know there are differences in different jurisdictions. I know there was a study conducted by the Government of Canada in 2022 on that, but again, and I think it ties into justice partners and community partners. What's the frequency of youth conferences in your jurisdiction, and what information is being sought and can be of assistance?
So the frequency, unfortunately, I would say is very poor, only because culturally they haven't caught on. Even though the statute's 20 years old, even when I was a lawyer, I found that it was just unusual. I would ask for one once in a while, and sometimes people would look at you like, what are you talking about? We have to work on that. I'm trying to encourage them as much as I can here now in our new courthouse at 10 Armory Street in Toronto. But again, you know, nothing precludes anybody from asking for one. I mean, you know, just bring it up, let's talk about it, and find a judge who's interested. We've got a devoted youth team here. We'll make it happen. You know, and really who comes and what happens in one is so unique in each case. But all options are on the table. You know, let's bring the youth in, the parents if they want to be there, anyone else involved in the young person's life, Crown Attorney's office, defense counsel, of course. And I'm open to suggestions always. We can bring in other people. I mean, there's really no limit to who wants to be involved. You don't want it to be too unwieldy, but usually I find it's fine. And then let's just talk about what's happening. You know, I want to know better on a day-to-day or week-to-week basis. How is this young person just getting by? What's happening, you know, with them? And are they doing well now? And is what happened that brought them to criminal court a one-off? And it's been months now, which is like an eternity to most youth, and maybe it won't happen again. Or are they constantly re-engaging with the criminal justice system, and why? Like, what is happening and what can we do to succeed? And there's just no substitute for everybody sitting around, either a real table or a virtual table. You can do them over Zoom too, of course, if you prefer. And just having that discussion. And I know it's awkward when you have a judge in the room or something like that, but I usually start just by saying, look, this is a free place to talk. And I'll tell the young person and their lawyer off the top, nothing that happens in here will result in a worse outcome for the young person. There's no prejudice to the young person. This is just here to try to find out what we can do to work in favor of the young person. And the Crown's office almost always takes the position that they would not try to, I don't know, bad word here, but weaponize the, system in any way against them. These case conferences are just there to help. So let's see what we can do. And in my experience, they're very rewarding. So I keep pushing for them. If you come into this building with a case, just ask for one and say, Justice Jones told you to, okay? And then let's try to get them more popular and see the success rate go up. You're on mute again, I'm sorry.
I was thanking you again.
I'm sorry.
Thank you very much for that. Clearly, I think by the fact that they want to have your presentation as soon as possible is really reflects the importance of the topic and the interest. And I know there's clapping hands going up. People are muted. Thank you very much, Your Honor, for taking the time out of your busy schedule to educate us and open, I think, a lot of areas of discussion and reflection. Yes, you are sure you're very busy. You're welcome to stay for the next session if you wish, but otherwise we want to thank you. And if you can send your presentation to the website, not the
Yes.
website, the email address, it would be very appreciated.
Absolutely. All right. Well, thank you, everyone. Have a great day.